Good afternoon, everyone. Welcome. I hope you all can hear me. I hope you see our slides. Welcome. Hope you're comfortable. So am I. Let's have a chat. At Altius, we often draft and review intellectual property license agreements, and my colleague Bart and I, we were discussing this over the last couple of weeks, and we thought, for this IP update, let's try to convey where our mind goes when we review IP license agreements. So what do we think are common pitfalls, common mistakes, or areas we see that are sometimes a bit neglected? And let's share those insights with you. Disclaimer. So as far as the agenda goes, in part one, Pat will give a very brief introduction as to the basics. So he will answer the question from a legal point of view, what is a license agreement? Now, I'm sure all of you at home have seen license agreements before, but the basics are important. Really, a sound understanding of the foundation of a license agreement is necessary to draft a good license agreement. In part two, then, I will take you, together with Pat, through the common pitfalls and key issues. And our goal today is not to be exhaustive, and we won't cover everything. We won't cover tax issues, we won't cover transfer agreements and the like. But now we are modest people, and I think we will have succeeded if the next time you have a license agreement in front of you, if you remember 3 bullet points from our slides, and you're able to improve your draft, then Bart and I, we will be very happy people. So on that note, I give the floor to my colleague Bart.
Good afternoon, everyone. Also from my side, welcome to this IP update. And as was just said by my colleague Brecht, we will start this first part of the presentation with a basic overview of license agreements from a Belgian perspective. Now, when talking about license agreements, a logical place to start is their subject, namely an intellectual property right. And this can be defined as the legal protection of an externalized creation of the mind, because we deem it beneficial to stimulate and reward innovation. This legal protection is, however, not endless. First, intellectual property rights have a limited territorial scope, meaning that the holder can only enforce their IP right in a certain geographical area. Put simply, a Belgian patent only guarantees protection in Belgium, while a European patent guarantees a broader protection across Europe. Secondly, the protection of an IP right is, in principle, limited in time, although some can be renewed, as we will see later on. An informal distinction is often made between hard IP and soft IP. Patents and plant variety rights are considered to belong to hard IP, while other forms of intellectual property, like trademarks, copyright, and designs, are considered soft IP. Now, this table that you see on the slide gives a basic overview of some of the most common IP rights out there and some crude definitions. It also makes clear that each IP right treats a different subject matter, although accumulation of multiple IP rights is possible when all the legal requirements are fulfilled. Additionally, you will also see that the duration of IP rights differs, not only as to their lifespan, but also as to the possibility of renewal. For example, a trademark may only last for 10 years, but can nevertheless be endlessly renewed, while copyright lasts for the life of the creator plus 70 years without the possibility of renewal. Now, for the sake of completeness, mention should also be made of the protection of databases, trade secrets, and supplementary protection certificates. This last one provides for a time-limited extension of patent protection for certain pharmaceutical or plant protection products. Equally important for us is to emphasize that IP is essentially a negative right, meaning that it can be invoked to exclude others from performing certain actions. For example, a patent implies the right to prevent others during a certain period of time to manufacture, use, or sell an invention in a certain territory. The holder of the IP right can, however, choose to partially let go, so to say, of its negative right by means of a license. In essence, the license works as a permission for a third party, granting them rights to exploit the subject matter of the IPR in question. A license should nevertheless be distinguished from a transfer. The latter namely implies that the ownership of the IP is transferred from one party to another. Usually, this happens between an employee and an employer, where IP created by the employee during his or her professional activities is assigned to the employer. Such IP transfers are, however, outside the scope of this presentation. The only caveat to be made here is that in competition law and in the European Commission's technology transfer block exemption in particular, the term technology transfer is actually considered to be a license. Now, we realize that this is confusing, but since competition law is a self-standing area of the law and not a mere addition to IP law, it is not bound by the terminology of the latter. However, confusion can be avoided by simply remembering that the technology transfer block exemption covers technology licensing agreements in relation to most intellectual property rights. Now, finally, and for the ease of reading throughout this presentation, the abbreviation LO stands for licensor, the one that grants the license, while LE stands for licensee, the beneficiary of the license. Now, since a license is a contract, the general principles of Belgian contract law apply, and we will highlight some of the most important ones here. First, a license agreement is an undefined contract in the sense that it is not specifically regulated by the law, like a sales contract is regulated in the civil code. However, general contract law and the freedom of contract still apply to license agreements. Moreover, there exist special rules depending on the IPR in question and imperative rules that need to be respected. This is something we will treat in the second part of our presentation. Secondly, a license's qualification as a contract means that it binds the parties, or to use terms of the civil code, the contract has power of law. Also, the license needs to respect the basic conditions of validity of a contract, such as a valid consent of the parties, a lawful object, and a lawful cause. Thirdly, and as with any agreement, a license agreement might very well have to be interpreted at a certain point in time, especially when a dispute about the license agreement arises. That's why we emphasize a good structure and clear language in the contract. This is all the more important because it is a general principle of law that the language of the contract forms one of the main bases for interpretation, without, of course, blindly focusing on the literal wording of the contract or its specific provisions. This principle is also found in Article 5.64 of the new Belgian Civil Code. Additionally, courts also consider the party's intent when interpreting a contract. That is the reason why the preamble should not be neglected, as it reflects what parties aim to achieve aside from the substantive provisions of the contract. Now, with this in mind, we can already share the following core tips with you. Now, 1, use clear and precise language, since the language of the contract is one of the bases for interpretation. And that clarity of language should not only apply to the parties to the contract, but also third parties. Moreover, a contract should be tailored to the specific situation, and thus it should clearly identify what the parties want to achieve. 2, anticipate when drafting. Parties may enter into a contract today, but intend to invoke it in the future. Most of the time, parties agree to a contract under relative happy circumstances. They consider themselves to be partners and equals, each deriving a fair benefit from the contractual relationship. So as not to spoil the mood, parties run the risk of not being precise enough in the wording of certain provisions, or consider some elements as obvious, although they might not seem that obvious a few years down the line when litigation has started. Thus, The moral of the story is that how an agreement is drafted should not only play a role in the actual formation of the contract, but also in anticipating potential enforcement so that your rights are sufficiently protected. 3. Be mindful of imperative law and specific rules, as they may oblige you to include certain provisions in the contract, or on the other hand, significantly limit what you can include in the contract. This is also something we will touch upon later. We now move away from the theory, which has served as some sort of stepping stone towards the second part of the presentation, and one might even say the main attraction, relating to common pitfalls and key issues of license agreements. We will first look at a number of formal requirements applicable to license agreements. First off, the necessity of having a written license agreement depends on the IPR in question. For example, when the subject of a license agreement concerns a patent or plant variety right, the license agreement needs to be in writing. The absence of a written license agreement in those particular cases will lead to the nullity of the agreement, denying parties the possibility to draw any rights from it. As a general rule, however, it is highly recommended to have a license agreement in writing, even if only to prove the actual existence of the agreement. The requirement of registration is generally not one of validity, but one of enforceability. As a general rule, third parties must tolerate the existence of a license agreement. However, this rule does not apply to agreements on industrial property rights such as patents, trademarks, and registered designs. To be opposable against third parties, these agreements must meet so-called publicity requirements. Parties must register the license agreement with the competent authority who is responsible for administering the relevant intellectual property right. To avoid discussion, the parties could provide in the license agreement who is responsible for fulfilling this requirement and who bears the costs of registration. In that sense, registration is crucial in a case of a transfer of a patent where the licensee can invoke its status against the new owner of the intellectual property right, or if a licensee wants to bring a claim in court, whereby a registration will certainly help to prove its status as a licensee. Next, the language of the agreement remains the free choice of the parties. However, it goes without saying that the chosen language should be well understood by all parties involved. In principle, license agreements do not have to be dated, but this is again highly recommended for evidence purposes. For example, when dealing with consecutive contracts. Sometimes it could also be relevant to determine the entry into force of the agreement. To give you an example from our practice, there was a dispute about whether technology relating to a particular type of machine was licensed or not. There were several documents available, but it wasn't very clear from those documents which one constituted the final agreement. The dispute was eventually resolved by relying on one of the documents that was actually dated. Lastly, as to the signature of the agreement, this is also recommended for evidence purposes, but is strictly speaking not a validity requirement. Moreover, the common phrase read and approved does not flow from any legal obligation and has thus no relevance. To be fair though, such a handwritten phrase is imposed by the Code on Economic Law in relation to, for example, consumer credit agreements, but this cannot be transposed to license agreements. The same could be said of adding the parties' initials on every page of the license agreement, although it can sometimes be used as proof of consent to every single page of the agreement. The electronic signature of an agreement is also valid. Although only the qualified electronic signature is considered equal to a handwritten signature. Courts do have a margin of appreciation when it comes to normal and advanced electronic signature, in the sense that when such signatures are contested in court, the additional evidence to support their authenticity is freely assessed by the judge. As some sort of warm-up, this is in our view an example of what not to put in a license agreement. And actually, this is not some made-up clause. This is a clause we actually encountered in the license agreement of a South European client. Now, to give you slightly more context, this clause was inserted at the very end of the license agreement and even after the signature of the parties. And if you look at this clause in detail, you will quickly notice that it singles out certain provisions of the license agreement and then states that the parties declare that they expressly approve the following provisions. Now, the passage expressly approve has no meaning under Belgian contract law. You either approve something or you don't. Such clauses should, however, not be treated lightly, because in this particular case, it would seem that the provisions that are not mentioned in this clause or the annexes are of a second tier, so to say, or even worse. It could imply that there is no approval at all of those clauses or annexes. So again, the freedom of contract should not get in the way of only inserting clauses that are clear and logical. We will now take a brief look at what the key clauses are usually contained in a run-of-the-mill license agreement. What you see on the table, on the slide, is a schematic representation of how a license agreement can be divided into different clauses, regardless of the applicable intellectual property right. Now, the clauses indicated in bold will be treated in more detail by Brecht in a few moments, and I will briefly walk you through the remaining ones. There is, of course, the preamble, and as we have alluded to earlier, this is a reflection of the parties' intent in relation to the license agreement. It should therefore be carefully construed. This is not merely theoretical, since we've had a case whereby the crux of the dispute centered around the interpretation of the preamble instead of one or multiple substantive provisions of a license agreement. Now, since the license agreement is a reciprocal agreement, it generally contains obligations for the licensor and the licensee. On the side of the licensor, he is bound by a maintenance obligation in relation to the IPR in question, for example, by being required to timely pay the necessary fees to the competent authorities. On the side of the licensee, there is often an exploitation obligation in order to ensure that the value of the IPR is not lost. The consideration or royalty is also an important part of a license agreement, and in particular, how the royalty should be calculated and what the method of payment should be. Parties are, however, free to tailor this to their own liking. An audit clause is also usually inserted for the benefit of the licensor. Depending on the strength of the licensor in the negotiations, the audit right can be narrow, where there is a control of the royalty calculations, or broad, where the licensor can even check the compliance with the license agreement in general. Improvements and no challenge clauses also exist. The former refers to the clause whereby improvements in relation to the licensed technology belong to the licensor. The latter refers to a clause whereby a licensee binds itself not to challenge the validity of an intellectual property right in question. It should already be noted that these clauses could be problematic from a competition law perspective. And finally, there is the classic clause about the applicable law and forum. I will now leave you in the capable hands of Brecht, who will guide you through the other key clauses of license agreements and what could potentially go wrong there, as well as the rules of imperative law and in particular competition law.
Thank you, Bert. Let's delve into the license agreement with the first top of the parties. So the licensor is the party who grants the IP rights to the licensee. Now, that sounds easy on the surface, but be mindful that legally speaking, only the holder of the intellectual property right can actually grant rights. So it's important that the correct legal entity in the agreement fills the position of the licensor. For intellectual property rights that are registered, like plant variety rights, patents, trademarks, you can, of course, check it an online database, an online register, and there you can see which entity holds the intellectual property right, and it will be that entity that has to fill the role of the licensor in the agreement. Now, When there are two parties, standard licensor, licensee context, this is pretty manageable. Where sometimes there's one more level, and then it gets a bit trickier. So this is a situation shown on the right of the slide where you have a master license between a licensor and a licensee, and then the licensee grants a sub-license. So all the way at the bottom, you have a sub-licensee, meaning that the licensee also acts as a sub-licensor. Now, in that context, for the sub-licensee all the way at the bottom, it's important to know that the rights she is being granted are actually in compliance with the rights granted by the master licensor to the sub-licensor. For example, let's make it very concrete. If the sub-licensor is granting the sub-licensee the rights to grant to sell a product in Spain, but according to the master license, the sub-licensor actually doesn't have any rights in Spain, then there's a mismatch, and the sub-licensee can get into a lot of trouble if she starts selling products in Spain. So how does that get resolved in practice? Well, the sub-licensee will typically ask for some form of insurance. Right? There's more than one way of doing that, but we've listed a couple of examples on the slide. So one thing you can do there as a sub-licensee, you can simply ask a copy of the master license agreement between licensor and sub-licensor, and check yourself at that point. Just take a look at that agreement, check, okay, does this make sense? Is this in compliance with the rights I am being granted? But as you might already feel, that the sub-licensor will often be hesitant to share this agreement for confidentiality reasons. So an alternative to that, and something we see in practice, is that you can ask the master licensor to co-sign the sub-license agreement. Or if the master licensor is not willing to do that, they may sometimes issue some form of written confirmation, like a letter of comfort, in which they confirm that the terms of the sub-license agreement are in compliance with the rights granted to the sub-licensor. And finally, regardless of example 1 and example 2, what we also see in a lot of cases is that the sub-licensee will ask for contractual insurance, if you will, in the form of a representation or a warranty. So what that would look like is the parties include a clause in their contract in which the licensor warrants that he has all necessary authority, capacity, and power to grant a license, and that he has taken all required actions and has all required approval to enter into this agreement. And the idea behind that kind of clause is then that if the sub-licensee at any point gets in trouble, at least she has contractual redress vis-a-vis the sub-licensor for compensation. So that's side of the licensor, side of the licensee then. Well, as a licensee, I think you should be mindful that in principle, only the licensee, only that entity is granted rights under the license agreement. So as Bart very correctly put it in the beginning, an IP right is a negative right, and the license agreement really is the permission granted to the licensee. So only the licensee receives the permission. By implication, this also means that the right to grant sublicenses cannot be assumed. Now, this matters in practice because let's take an example. A licensee wants to involve some of its affiliated companies, subsidiaries or daughter companies they want to involve them in the licensed activities. But those subsidiaries, those affiliate companies are not granted any right to do anything under the license agreement. And so you cannot assume that they can now also perform the licensed activity. To the contrary, what you would actually need to do as the licensee, you would need to grant sub-licenses to these affiliated companies. But if you don't have the right to do so, then you can't grant any rights to these affiliated companies and they cannot perform any of the licensed activities. So, to put it briefly, as a licensee, you have to be mindful that, okay, is the party that is entering into the contract, into the license agreement, is that the company that will perform the licensed activities? Now, let's take a look at a couple of examples just to make it concrete of different setups. So first example is a trademark license. The licensor grants rights to a licensee. And it's expressly provided, as we see very often, that the licensee shall not have the right to sub-license without the prior written approval of licensor. So in that scenario, let's say a licensee wants to grant a sub-license to a daughter company. Well, only the licensee is granted a license. To do that, to make that sub-license to an affiliated company, it will need the prior written approval of the licensor. The second example, so same trademark license, let's assume, and Here, the parties anticipated. So the licensee knew beforehand, oh, wait, my affiliates are going to take care of the export of the product. So the parties negotiated and they put this into the agreement and they said, okay, the license is granted to the licensee. The licensee shall not have the right to sublicense, but there's an exception. I do have the right to sublicense to my affiliates the exports of the product under the sign. So because they anticipated that scenario, license agreement is now more clear. And the third example is, let's say there's lots of affiliates. The licensee is a big company and they want to make sure that all their affiliates are covered by the licensed activities. The parties negotiate and they put this in the license agreement and they make sure, okay, license is granted to licensee and its affiliates, and then there's no need to grant sublicenses. These are, of course, just examples. It's just to give you an idea of how this can play out in practice. So in the contract, we've had the parties, and then we usually have the preamble, as Bart said. And then typically what the license agreement will do is we'll set out a list of definitions. Often this is Article 1 of the agreement, but sometimes terms are also defined throughout the text. Definitions are not mandatory, they're optional, but honestly, I would say I would recommend using them. I actually think that I don't know what Pat thinks, but I actually think that out of all the clauses we look at when we review license agreements, my intuition is that the section of the agreement we most often make changes to are the definitions, and that's because they're crucial, right? So all other clauses rely on the definition, so their importance cannot be understated. I mean, just to give you a super simple example, if you're negotiating a trademark license and the agreement starts with the definition of trademark and you define the trademark sloppily, then your whole agreement is basically tainted. So, of course, in the first place, definitions have to be accurate, and that depends on specific circumstances of the case. Be mindful, pay a lot of attention to those definitions. But there's also one tip that you can keep in mind, I think, for every license agreement, and that's the following practice. So capitalize the defined terms and use those capitalized terms consistently throughout the text. As I already said, if you're sloppy, this can have very important implications. Because if you want to use a certain term, but you use another term, or if you want to use a defined term, but then you don't use a capitalized term, you risk saying something completely different than what you mean. You risk saying the exact opposite, actually. And this brings me back to one of Bart's core points, that something might be obvious to you, but if you ever have a dispute and you end up in court, a judge who is a complete outsider will have to interpret the agreement. And the judge will look at the wording of your agreement through a strictly legal lens. And she will not know what you intended if you do not make it clear. Sometimes clients instruct us that they want a license agreement that they can reuse for similar situations. Now, in that respect, I would say first tip is don't blindly copy paste from different license agreements, but there is a way, I think, in which you can create like semi-templates that work in similar situations, and that's you do that by working with annexes. So very concretely, you have certain concepts in your agreement that require some flexibility. Take, for example, the definition of the term of the agreement, or the definition of the territory, or the royalty calculation. And what you do is you define them in the agreement, you define them in your Article 1, but you then refer in that definition to an annex. And the practical consequence of this, it seems easy, but the practical consequence of this is that if all is well, you can reuse the agreement, and next time for the second similar situation, all you need to change is a couple of words in the annexes, and the biggest chunk, the body of the agreement, remains untouched. The third tip of something that can have big implications is working with organic definitions. What do I mean with organic definitions? We'll make it clear just if we run through the examples. I think first example, taking a patent license now, you may want to have flexibility depending on the setup, and you may have to at some point add further patents to the license agreement. Now, at that point, if you already know that that's going to happen, you should anticipate that and make that clear in the definition. Preferably, you should probably also think about a mechanism or about how you're going to do that. How are you going to add further patents to the agreement later on? So in this example, the parties defined patents as all patents and patent applications. They listed them in Annex 1, but they anticipated and they said, look, we might add future patent and patent applications to this annex, and we're going to do that in accordance with Article 7.2. It's just for clarity reasons, and it improves the license agreement. The second example addresses something which parties sometimes forget, and that's especially important if you're a licensee. So imagine you're being granted rights to a patent or any IP rights, and at the point of entering into the license agreement, that IP right is still an application. What you want to do then is you want to make sure that you clarify that the actual IP rights, the actual patent in this case, that follows from the application is also included in the license agreement. And this is what the underlined sentence clarifies. So without the underlined sentence, what we have is a definition of patent that says all patents and patent applications listed in Annex 1 to this agreement. Okay. What might happen though, if you don't include the underlined sentence, is that imagine there's one patent application today, and it's 30 March, and in 2 years it gets granted into a patent. And as a licensee, you assume, okay, now I also have the rights to the patent, right? And the licensor says, no, because we listed the patent applications in Annex 1 and it doesn't include the patent that followed therefrom. So to avoid that dispute, you can clarify this by including that the patents as we define them in the license agreement are not just those listed in Annex 1, but it's also the patent applications, including the patents ensuing therefrom, ensuing from those applications. Third example then deals with a similar situation. So let's say the licensee wants to use a certain patented process, but it's possible that the process is covered by multiple patents. And you should be mindful in that scenario also that there might be additional patents in the future granted that also cover the process. So let's take a look at the concrete example. So the parties define the patents and they say it's all patents and applications, including assuming they're from. And it's all those patents that are owned by a licensor that cover the process. But the parties clarify, look, we know there might be more in the future, so it's those patent applications now in existence or hereafter granted. Just to make it clear and to avoid confusion, to avoid legal headaches later on. Okay, that brings me to the scope of the license agreement. So we've had the parties, preamble, Article 1, often definition, and then we reach what's probably the most important clause in your license agreement. It's often Article 2, the core of the agreement. So I already mentioned it, Bach already said it, I'm going to repeat it again because it's, I think, a real fundamental part of licensing. That's the IP is a negative right. So the very purpose of the license agreement is to specify the contours of the permission granted to the licensee. So the one thing this clause, we've named it Article 2 now, has to get right is to identify the rights of the licensee. And of course, as Pat also said, the parties enjoy contractual freedom. So different setups are possible. Sometimes parties agree on what you could call a complete license, meaning that the licensee is granted freedom to do whatever the IPR was actually supposed to block. But more often, the license will be limited, meaning that the agreement will specify in more detail what the licensee can do and what the licensee cannot do. As I said, parties can get creative. Something we also see, and I put it as a tip on the slide, is especially in situations where there are multiple IP rights that are being granted, we see that this Article 2 gets a bit back together in one big complicated clause. So my tip here would be to untangle that. So let's say a license is being granted to a plant variety right in a trademark. Untangle it and just draft it in a way where you say, look, in respect of the plant variety rights, licensee shall have the right to ABC. In respect of a trademark license, licensee shall have the right to ABC. And that's helpful for an outsider, like a judge, because in reality, the plant variety right and trademark, there are different titles. Another important thing to keep in mind here, especially if you're a licensor, well, if you're a licensor, it will be beneficial if you exclude implied rights. And what do I mean by that? Well, the exclusion of implied rights, what that does is the licensor's way of saying, look, I'm granting you certain rights, we're putting them in these agreements, and it's nothing more. So this is the line we're drawing. This means, of course, as a licensee, that you should be mindful that you cannot take anything for granted, right? If you're unsure whether a certain activity that you're planning on doing is covered by the license, you will not get away with the argument, I thought we also included this. I thought this was implied. Maybe it'll become more clear if we look at a little bit at the example. So the first example is a copyright license, a synchronization license, and the parties agree and they say, look, the licensor is granting to the licensee a license to synchronize a recording, music, whatever, to any other type of content. So for a commercial or something. And then underlined, what follows is the exclusion of the implied rights. So the licensor says, look, I'm granting you a license to synchronize a recording to any other type of content, but only the license granted under the express terms of this agreement shall have any legal effect. No other license right shall be created by implication otherwise. So it's the synchronization license and nothing else. The second example is, I think, very typical license agreement language. It's a different way of saying that implied rights are excluded. And it goes like this. So a licensee shall refrain from engaging in any other acts not expressly authorized under this agreement. And then you can list some examples if you want. A licensee shall, in particular, licensee shall not A, B, C, D. A topic that also comes up a lot when we talk about the scope of the license agreement is exclusivity of the license. And it's normal for this to come up because, of course, it has important business implications. Now, I want to clear some conceptual confusion here. Although there are no binding legal definitions in the law, generally you can distinguish between these three different types, broadly speaking, from an exclusivity angle. So an exclusive license is a license where only the licensee may exercise the named rights. So the licensor also refrains from exploiting the IP. A non-exclusive license is one where there's no commitment. And then a sole license is a license agreement where the licensor commits herself not to appoint other licensees, but she can still exploit the IP rights herself. So please be mindful that the word sole and the word exclusive, they mean different things. And as I said, the difference is in a sole license, the licensor still has the right to exploit the IP rights. And what we sometimes see, and I think this is a mistake, parties are well intended and they want to make sure, they want to stress that the license is exclusive, or they saw this in another license agreement, and they write something along the lines of licensor hereby appoints company A as its sole and exclusive licensee. So this terminology, sole and exclusive, is very tricky because, in my opinion, it's unclear and it can even be seen as a contradiction and thus as a sort of conflict. So my tip to you would be, don't use terminology sole and exclusive. This actually brings me to another very common pitfall, and that's, I think parties forget to elaborate on what they mean when they say their license agreement is exclusive, right? So often you will see a license agreement and it said the title, very big bold letters, exclusive license agreement, but then when you look through it, there's actually not a lot of information in there, like, what do you mean exactly exclusive? How are you interpreting this? So really, I would personally recommend to add a paragraph and explaining, okay, it's an exclusive license, but one, does that mean that the licensor does not commit to appoint, the licensor commits not to appoint other licensees? Or will she also commit from exploiting the intellectual property herself? And secondly, are any of these commitments limited to a certain territory, right? So again, it's very, like a very easy example. If you say, I will not appoint another licensee, period, that's completely different from saying, I will not appoint another licensee in Spain, right? So the parties can use territorial nuances to define this notion of exclusivity. Having said that, I do have to wave a little flag here and bring your attention to the fact that once you start regulating territories, you should be mindful of competition law, and I will come back to that at the end of the presentation. Now, a structure that requires additional attention is sublicensing. So we touched upon it a little bit in the beginning, and as I said then, the right of the licensee to sublicense is not implied because only the licensee is granted the IP rights, only the licensee is granted the permission. But let's assume that parties agree that the licensee can grant sublicenses. Sometimes this is, of course, also beneficial for the licensor because let's say the parties agree on a royalty that's dependent on net sales, and the licensor thinks, well, if there's more sales downstream, more royalty revenue for me. So let's assume the licensee can grant sublicenses. Now, the licensor will tend sometimes to feel some hesitancy, will not be very keen on those sublicensees because it means, of course, that the licensor is losing some form of control, and there will be other parties, other sublicensees further downstream, with which the licensor, the master licensor, will not be in direct contact. So we often advise on how to keep a grip on that overall structure. We've grouped some basic tips together on this slide to do that. And I think the first thing is, again, it's an easy point, but still sometimes forgotten. Make clear in the master license agreement that all sublicense agreements should terminate upon termination of the master license. So you can argue that this is implied, and that's fine, but it's always better to be clear. It's an easy one, put it in there. I think it helps the clarity of the license agreement. A second tip here is clarify whether the sublicensee, so all the way at the bottom, whether the sublicensee has the right to grant further sublicenses. Again, it's a very easy thing to do. You make it clear that, okay, licensee has the right to grant sublicenses in accordance with Article 5, whatever. And then you specify, but without the right to grant further sublicenses, just to make sure that, okay, I want to stay in control. You can add another level downstream, that's fine, but we're not going to go even another level further downstream. The third tip, if sublicenses are granted, right, this means that more parties will be exploiting the intellectual property downstream, and it should be clarified how this affects the royalty obligations of the licensee. And the easiest way to go here, I think, is by stipulating that the royalty obligations cover the activities of the sublicensees. So to stipulate that the master licensee, the one in the middle, remains responsible for all payments. And then it's the responsibility of the licensee to take care of payments further downstream. And that structure, what it does is it gives the licensor one central contact point, namely the licensee, where she can collect royalty payments. Now, the fourth tip concerns document control. And what I mean with document control is a licensor, all the way at the top, does not have an agreement with any of the sublicensees. So how does the licensor ensure that the licensee actually grants sensible sublicense agreements? Again, there's different ways of doing this, but I think the most effective way is by imposing a template sublicense agreement. So typically what you do then is you make a sublicense, you put it in an annex, and then in the article that grants the licensee the right to grant sublicenses, you say, yes, you can grant sublicenses, but this is provided that you follow the templates sublicense agreements. And you can even fortify that if you want by including an extra consent agreement that the licensor has to then consent to the sublicense agreement before licensee and sublicensee enter into the sublicense agreement. An alternative, which we also sometimes see that's less intrusive and gives more flexibility to the licensee, is to stipulate that the licensee has the obligation to enter into a written sublicense agreement under terms no less stringent than the master license agreement. So that's the licensor's way of saying, look, okay, we're going to grant sublicenses, that's fine. Please enter into a written sublicense agreement so we keep oversight, and the terms of those sublicenses should not be less stringent than one of our license agreements. One tip that I also want to mention here, in those licensing, sub-licensing contexts, different documents will come into play. And at that point, it's beneficial for the licensor, but also beneficial for general clarity to specify that in case of conflict or doubts, that the terms of the master licensee, the master license agreement always prevail. Again, it's a small, it can be a small paragraph, but it really enhances the clarity, and I think it's recommended to put it in the master license. A fifth observation that can aid the licensor in keeping a grip on a situation is by including a direct audit rights for the licensor. So giving the licensor audit the sub-licensee. That way, if ever push comes to shove, let's call it, the licensor has a direct way of checking the activities of the sub-licensee. And finally, in this context, 6 bullets, a way for the licensee to keep a grip on a situation is to put in the agreement that licensee remains responsible and liable for all acts of all sub-licensees. That way, same with the royalty obligation, the licensor has one point of contact. Of course, this is far-reaching, and oftentimes the licensee will push back on that, but it's advisable to at least clarify what the relationship is between whether the licensee remains liable and responsible for acts that happen further downstream. And the best situation for the licensor is, of course, to make it expressly clear that the licensor doesn't care. It says, look, I have one point of contact, that's you, licensee. You remain responsible and liable for everything that happens downstream. Another pitfall that I want to briefly touch on, because duration and termination is something that can also get very complicated in a license agreement, but I just want to mention one pitfall here, and that's we sometimes see that parties agree on what they call a perpetual license. So I put an example on the slide. So let's say company A and company B, they work together, and company A provides certain materials to company B that company B can then build something with. And they collaborate, and then after their collaboration, for company A, the licensor says, look, you're gonna go and work with the materials that I provided to you, so I hereby grant you a license that's non-exclusive and royalty-free to use any of those materials that were accessible to you during the term of this agreement. And they say, let's make it a perpetual license, right? So that notion of perpetual, I think, is a dangerous concept, because under Belgian law, there's actually a general prohibition on committing oneself for eternity. So what happens if you grant an eternal right? So under Belgian contract law, there are, in essence, I think, 2 solutions. One option is, and this is the option stated in the law, is that the term of the agreement will be reduced to 99 years. Very random number, but that's the number in the law. Another possibility is that the license agreement will be requalified into an agreement of indefinite duration. And at first glance, an agreement of indefinite duration might not seem so bad, but be mindful that this really creates a precarious situation. Because under Belgian law, an indefinite contract, an indefinite license agreement, for example, can be terminated at all times with reasonable notice. So in other words, this creates considerable legal certainty. You thought you had a perpetual license, but now it gets requalified into work that the licensor, the licensee, can terminate at any point. So a common solution we see in practice is that the parties agree to grant a license for the duration of the IP, right? That way it has a fixed term and it's clear, and it's often used in practice like that. Okay, so if we go further down the agreement, in the back at the end, what we find is the boilerplate. So the boilerplates, these are all the clauses that are generic. For example, think about confidentiality obligations, non-waiver obligations, notification obligation, and the like. Now, first thing I want to say here is be mindful. It's not because these are generic clauses that they cannot have a big impact. One typical example of something you see in the boilerplate is a definition of force majeure. And those can have a significant commercial impact, as we now know, with pandemics and wars happening. So be mindful, it's not because of the boilerplate that you shouldn't look at it. Also, when it comes to the boilerplate, there's one tip that I really want to make sure to mention, and that's to add a severability clause. So what's a severability clause? I put an example on the slide. It's when the parties agree that if one or more provisions, part of provisions, is held to be invalid, that the remainder of the agreement still remains in full force. And I think a severability clause really is useful because it avoids surprises, it increases legal certainty regardless of context. Really, in my opinion, a good severability clause is an asset for any contract. And that brings me to the final part of the presentation. That's great. Imperative law. So Bart mentioned in the beginning, the principle is that general contract law applies. Parties have contractual freedom. They decide on the content of the license agreement. But there's one important caveat here. The parties cannot escape mandatory rules. One notable example is competition. So if the parties misbehave, if they deviate from imperative law, this can lead to problems of nullity. And at that point, of course, the importance of the severability clause will surface if you wish to salvage your agreement. Let's very briefly look at competition law, and I mean it when I say very briefly because competition law, we can do a whole presentation on competition law, but I just want to flag some key takeaways before we wrap up. So competition law regulates how companies behave towards each other, and competition law interacts with license agreements in at least 4 ways. So one way is if you fix the price of the licensed product. So licensor says to a licensee, yes, here's an IP rights, you get permission to produce this product. And if the licensor then imposes a price for that product further downstream, that's a competition law problem because this is price fixing. Another area where competition law comes into play is with so-called no challenge clauses. Bart already mentioned them, so there's an example on the slides. This is very typical language, but my message to you is this should be examined under competition law. It may be problematic depending on the parties' market shares. And the same goes for exclusive grant backs. So exclusive grant backs we typically see where technology is being licensed, and the licensor will want to make sure that, well, if the licensee improves on the technology, that she reaps part of the benefit. And so also with exclusive grant backs, the basic warning applies. It may be problematic depending on the party's market share. And the fourth area, which I will briefly go into on the next slide, is sales restrictions. So what are sales restrictions? Well, if the licensor restricts the territory into which or the customers to whom the licensee may sell the contract products, that's what we call a sales restriction. And this can be problematic under competition law. Now, there are a lot of rules we can talk about here, but the basic principle is, and I really think that this is the key takeaway, the licensee should be free to sell where and to whom she wants in the European Economic Area. So as soon as in your license agreement you want to restrict that freedom of the licensee, please remember that this requires legal attention. So doing so illegitimately is a hardcore restriction of competition laws. For example, you appoint a licensee and you say, look, you can sell these products in Spain, Italy, Portugal, but not in Germany and not in France. Like, well, wait a second, this might be problematic from a competition law angle. We need to take a look at it. The analysis depends on whether parties are competitors or not. So if they're in a horizontal relationship, in a vertical relationship, the analysis also depends on the market share of the parties. Overall, I think I will keep it brief here. As I said, competition law is an area that's sometimes is perceived as complex, but it centers around a couple of basic ideas. And the one I want to share with you today, and I will repeat it, is that a licensee in principle should be free to sell where and to whom she wants in the European Economic Area. If you want to start regulating this, it's possible. I'm not saying it's impossible, but you really need to take competition law into account. Okay. Yes, before we wrap up, just wanted to let you know that at Altius, together with the Federal Public Service of the Economy, so the Ministry of Economics, we wrote a practical guide for IP license agreement. And this practical guide contains checklists, example clauses, more information on everything we talked about today. You can find it online for free in Dutch and in French. I'm not sure it's available in English, but it's definitely available for free in Dutch and in French. So please go take a look at that if you have any questions. And I also want to share with you a little scoop. We actually drafted an update, and it's going to be published pretty soon. I don't have an exact date, but I hope it will be before the summer. So definitely go take a look at that. Thank you. If there are any questions, we will gladly answer them. Questions? That's great. Okay. If there are no questions, thank you. I hope you enjoyed it as much as I did. Pat and I had a good time talking about it, preparing this, and it was a pleasure presenting to you. And we hope to see you at our next IP update. See you.